Good morning, everyone. My name is Esa Adita Rahmawati from Indonesia. Today, I will be presenting our presentation for the 8th International Conference on Business, Economics, Law, Language, and Psychology. The title of our research is A Study of Priority Principle in Indonesian Agrarian Law System. The authors of this research paper consist of 3 members. First, Sri Winarsi from Airlangga University. Second, Esa Adita Rahmawati from Gadjah Mada University. And third, Omar Mokhtar from Airlangga University. The first part is introduction. The land is one of the most critical factors in the life of a community, especially in the environment of Indonesian society, where most residents depend on land for their livelihoods. The existence of land is relatively not increasing. If the number of land rises, for example by reclamation of the coast, it will be unequal with the rapid population growth that all require land. We are talking about land rights in Indonesian agrarian law. We should look into Law Number 5 of 1960 concerning basic rules for agrarian principles, UUPA. And land rights can be divided into 2 types, Type 1 for a specified period and Type 2 with no specified period. However, the problem is, communities' lack of understanding regarding land rights Type 2 have caused problems in the community. If the land rights have expired, the government will erase the rights and declare the land as state-owned land. Here we present a case study of PT Pancawira Usaha East Java, who was the owner of the land and building assets in Surabaya, based on building certificate on behalf of the Patna Surabaya Paint Company. The land right was valid for 20 years and had expired on April 5, 2003. The assets are currently inhabited by Nur Yahya without any legal basis and are used for Mahadita law firm office. Nur Yahya argued that the land right, which previously belonged to PT Pancawira Usaha East Java, ended on April 5, 2003, and the land became state-owned land. So, in this research, we will discuss 2 questions. The first one is who is entitled or has priority over the state land with former rights? And second, is there a legal relationship between the subject of rights and their land after the end of the period? The second part is methodology. The research is an analytical descriptive law study. We examine the settlements of land disputes regarding Indonesian legal sources, specifically regarding the agrarian laws and regulation. The research used a legislation approach and a conceptual approach. The legislation approach focused on the applicable rules as an effort to analyze the hierarchical relationship, consistency, and suitability between the laws of control over land rights and other laws. The research also used a conceptual approach that is conducted by studying and analyzing concepts and theories about the legal consequences of land rights annulment associated with the status of ownership of land rights. Also, we did a case study from a local company. And lastly, qualitative analysis was carried out by presenting legal principles such as constitutional principles of laws and regulations and procedural requirements of law, as well as analyzing various social, economic, and political factors. The third part is discussion. Indonesia is a state based on the rule of law. The understanding of the Indonesian rule of law places the interests of individuals in a balanced way with the public interests. The existence of regulations in a country based on the law is a must. Hence, in the state of law, there is a principle of legality, which means that all good actions that are state, national, and social must be based on the law or regulations. Next, let's discuss the right of priority. The right of priority over land is the right to get a priority first or take precedence based on sequences of recipients of land rights to obtain recognition, award, or determination of land rights. In the case where right of building has expired, the land becomes controlled by the state. However, the position of priority rights owned by right holders is preferable so that his rights will be given back. Hence, even though the rights over land have been erased, they still belong to the former right holders. However, there are still those who argue that the right of priority is not a right that must be recognized. There is a contradiction between the natural law theory and a theory according to Ufianus and Fechting. According to natural law theory, a state cannot own a land in the sense of possessing, but the state can control the land without having to own for the public interest. And according to Ulfianus and Fechting, a state based on a special relationship could own land. In Indonesian land law, two principles contradict each other. On the left side, we have the principle of vertical attachment, and on the right side, we have the principle of horizontal separation. The colonial land law adheres to the principle of vertical attachment, and in contrary, that law adheres to this principle, which is the principle of horizontal separation. There is a significant difference between these two principles. The principle of vertical attachment states that land ownership includes the ownership of the building in the area, but the principle of horizontal separation states that the ownership of the land does not include the building above it. Now let's get back to the previous case study of PT Pancawira Usaha East Java. Based on our discussion and analysis, we can conclude that PT Pancawira Usaha East Java is the legal landowner. PT Pancawira Usaha has a priority to extend its land right because the building above is based on the horizontal separation principle. Mahadita Law Firm doesn't have any right permits or legal authority to use the land which was originally belonged to PT Pancawira Usaha East Java. Finally, we have reached the conclusion part of this research. Land rights are the legal relationship between the subject of rights and land, where the link has legal protection. The purpose of land rights is to provide legal certainty over the legal relationship so that those right holders can exercise authority or content of their land rights properly. In connection with the priority principle, the Indonesian government should immediately establish special rules relating to former land rights that have matured, whether the government will give priority to regain or return to state land so that in the future this land dispute can be avoided. Thank you for your attention, everyone. Here is the end of our presentation for our research titled A Study of Priority Principle in Indonesian Agrarian Law System. My name is Esa Adita Rahmawati, and my other team members, Sri Winarsi and Omar Mokhtar, wish you all a very good day from home.